Okay, so today we are talking about Title 101, understanding title. Now, this has been a bit of a journey for me. About 2 years ago, it actually would have been a couple days ago that we had our next broker summit that the Michigan Realtors puts on. And obviously that was canceled, unfortunately. It's a great event, but a couple years ago I went. And they have a reception the night before, and then the event, obviously, the day of. So I went to the reception, and it honestly wasn't that well attended. But I did meet a few guys that sell a title insurance company franchise. So it is not a joint venture, it is a franchise. And I was intrigued by the idea, primarily because I really love the idea of my transaction coordinator being my front desk person, being my title person. I feel like there's a lot of overlap there, especially in terms of paperwork. And I thought if that was all the same person, you'd have somebody who really knows the file, who knows the client. The chances of them having a good experience goes way up because there won't be that disconnect. Plus, obviously, the friction on me having to get the same information to all these different people is less. So that was really intriguing to me. So I kept going with the conversation with these guys, and blah, blah, blah. About a year later, I was opening my own title company. It is a franchise. Which it's not like a, here you go, here's your name, and we're done now. They're very actively involved. They do all of my title research. I use their attorney if I have questions of things that come up, and they do all the cash disbursement. But what we do is everything else. We get all the documents together. We call the city of Grand Rapids to see if there's a water bill. And then we do the closing. So that's been a really interesting, ride for me. Definitely have learned a lot. So hopefully what I'm going to do today is tell you what I've learned about the title industry, but I'm still a realtor. That's probably my first and foremost. So hopefully I can tell you about the title industry, but still from a realtor's perspective. Now, I do have Crystal on the webinar with me today, and she is our main title person for Graybridge Title. So if I do run into trouble, as far as, I know a lot, but I don't know everything. So if there are things that I need help on, she's here to back me up. So if you guys have questions, then just let me know. So let's just start with, what the heck is title insurance? I don't want to say that there's misunderstanding, but I guess one thing that I learned from opening a title company, I really thought of it as like closing services, and it is that. But what I learned is that it's primarily insurance. I really didn't think of it that way before. I knew it was insurance. I know that they insured title. But that's really the main source of revenue, is the title insurance policy. It is not the closing. The closing and the research are all the things that we do so that title is insurable. For example, we had somebody, I don't know how long ago, let's call it 6 months ago, that just wanted us to insure title. It was a cash transaction. He didn't really want a lot, but he did want title insurance. He was nervous enough that he wanted that. But then he ended up closing at his attorney's office. We're like, no, that's not going to work, because what closing means is signing the deed. And we can't insure something that we didn't make the deed and record it ourselves, because that's the part that, you know, where we could have a claim. So just as a little bit of background, but really, what does title insurance do? I'm just going to read it. It provides protection to a party owning an interest in real estate against loss or damage due to past defects or claims against the interest as insured under a policy. So what's really different about this kind of insurance as compared to, let's say, your auto insurance? When you go get an auto insurance policy, everything's good right now, and that policy is going to protect you in the future. You don't know if you're going to get in an accident or not. You want to make sure if something catastrophic would happen that you're covered. Title insurance is the one kind of insurance that actually covers the past. So that's definitely different. And it just, what it protects you from are things that you maybe didn't know about. That's why the title company's main job is to research all of those things, make sure that when the closing happens, that it's all done correctly, that it's recorded correctly, so that we can issue a title policy and say, yeah, here's our assurances that you aren't going to run into problems. Now, if you so the point in it being an insurance policy of the past is if you close and the next day put a new lien on, we are not going to cover that, of course. So that's what's different. So what's a title defect? We're insuring against title defect. So what the heck is a title defect? My daughter's 9, she just turned 9. And I asked her if she wanted to come on the webinar today, and she did not. She thought it sounded like the most boring thing in the whole world. She doesn't even know really what title means. So I'm just gonna trust that we all know what that means. But what's a defect? Is the right held by another to claim the property or to make a demand upon an owner of the real estate owner. So we just want to know if somebody else, if there's something that makes it where you can't use your property any way that you want. So that can cover a lot of different things. That could be a mortgage, so there's a financial interest. It could be an encumbrance of other kinds, something like an easement, an encroachment. Those things won't stop you from financing, but it might stop you from doing the things that you want on the property. And that's the kind of thing that comes up in our title search. That's why if you ever get a survey, often they want to see the title work because that helps them to know if there are any other defects, any other easements or encroachments. Liens are the things that we tend to be the most worried about from like our perspective in trying to close. That's what the title, or that's what the mortgage company wants to know. They don't want to be behind anybody else as far as liens. So we're going to do a search. We're looking for the chain of title. I'm sure that you've heard of that before. That's the series of transactions that affect title to a particular real estate property. So if it goes from this guy to this guy to this guy to this side to this guy, what we're hoping is that every time the ownership changes, that this guy's ownership interest is discharged correctly so that this guy doesn't have to worry over here. That's really what we're ensuring, is that chain of title. Now, in theory, if you've had a chain of title done in the past, nothing's changed. Like, you can't record things from 100 years ago now. So sometimes so the older something is, the less risk it is. But that's why we have the Register of Deeds. Nothing there goes away. So that's why we have the title exam team. They review each document instrument to determine its validity, identify liens, encumbrances, Identify parties with interest or encumbrance on title. There's two types of liens, voluntary and involuntary. A voluntary lien is where you voluntarily, obviously, let someone put a lien on your property. The most obvious of these is your mortgage, of course. You say, hey, I want your money. And they say, well, we want an interest in your property. And you say, okay, so that's voluntary. Involuntary is more when it's through judicial proceedings, such as you put an addition on your house, you decided you didn't feel like paying your contractor, maybe you thought he did a bad job. So the contractor sues you, the judge agrees that the contractor did the work, and so they throw a lien on your house. That needs to be discharged if you're ever going to sell. Probably the more common thing that we see as a lien is liens that happen through a judgment of divorce. That's really interesting. Actually, being in title makes me realize that I need to know more divorce attorneys, because I'm surprised how frequently they say, hey, you're getting divorced today. Your house is worth $200,000 today. So we're going to put a lien for the spouse who's moving out. We know you don't have $100,000 today. So what we're going to do is we're just going to put a lien on the house so that someday when you sell it, you need to give the half to the spouse that moved out. What we're seeing is they don't take into account closing costs. So the spouse that ends up keeping the house ends up bearing all the burden of all the closing costs. They just take the market value, divide by 50%, put a lien on for that amount, and then they go to sell it and realize that realtors aren't free, and there's all the other fees that go along, the transfer taxes and whatnot, and they're surprised that the $100,000 that they thought was their half didn't end up being $100,000. So that's something that's interesting to me, but that's the other involuntary lien that we see quite often, is just from a judgment and divorce. So what does a title company do? Who are the players? That's the other thing that, oh, there's a question, sorry. Does it always go through the court for a lien? No, it doesn't. It doesn't have to go through the court. And honestly, that would be probably more of an attorney question. I hate to say that, but I know you'd have to fight it in court if someone throws a lien on without it being, if you don't agree. But like Kristen's asking, what about some other outstanding bills? What if it was a contractor and they put a lien on, but it hasn't been to court? It does not need to go to court. But if you don't agree, then you'd have to go to court to fight that. So I don't know a whole lot more about that, unfortunately. I don't know if, Crystal, if you're on and you know more about how to put a lien on beyond that, but I don't.
As far as actually putting the lien on, I don't know the specifics of how that would happen, but typically most title companies are going to have an affidavit by owner that the owner is signing at close, of course. And one of the questions is, has there been any construction in X amount of time in the past that there could be a potential lien because the bill hasn't been paid? So of course they're signing off and stating, no, there is not. So if they ever lied about it, there of course would be issues with covering that.
Okay, thanks. Yeah, and I think they say within the last 120 days. So maybe that's the statute for them to put on a lien for non-payment. I don't know. So a title company is more of an insurance agent than they are an insurance company, if that makes sense. Probably not. Like our underwriter is WFG. I really like them because they're a little bit newer, a little bit hungrier. So what can happen sometimes, and I don't think everybody knows that this can vary from title company to title company, but just as an example, we had something, I don't know, a year ago, where there was a land contract that was super old. The guy defaulted, he took off. So obviously his land contract wasn't discharged. They couldn't find him. But they thought, who cares? That was 25 years ago. The title company, this is before I opened ours. The title company we were working with said, well, we care. We really need that to be discharged. Can you track down that guy? And they said, well, we didn't know where he was 25 years ago. We certainly don't know where he is now. And so what we did is go to some other title company, and they said, sure, even if he hadn't defaulted, that land contract would be over by now. We're going to go ahead and insure over that. That's a term that we use sometimes, saying, yes, there is a small defect. We think it's low risk, so we're going to issue an insurance policy anyway. So that is something that will come up. So if you run into something that is a little quirky and your title company won't cover it, feel free to run that past us and see if we will, because that's one thing that I've been really happy with our underwriters, is that they do have a little bit of risk tolerance. Now, obviously, that's something that wasn't high risk to us 25 years ago, a guy that disappeared, come on. But so they'll take those risks with us, which is great. Then, so the steps, kind of, you get it underwritten, then we do the search and the exam. We come up with a policy, and I'll kind of show you one of our, here in a minute, I'll kind of show you what one of our, and I'm sure you've all seen what the title commitment looks like. That gets issued. Take care of everything that's on there. Often that's obviously getting the loan ready. And then we go ahead and go to closing. So that's a big part of what we do, is making sure that everything is lined up and ready to close. That's probably the time consuming part for us, especially in this age of splits, where what we do is we have to coordinate with the lender, make sure all of our numbers match, and then we have to coordinate with the split, make sure all of their numbers match. One thing to know is that it is the buyer's title company that handles all of the disbursements. So that can be logistically important, especially if you have a seller who is really, really concerned about getting their money at closing. Make sure that you're communicating with them that only happens if the buyer closes first. Often what will happen is the other title company will get us their checks, because we kind of have an understanding we're going to respect each other as professionals, that they're not going to hand out checks that they shouldn't be. So, but that's important to kind of understand the steps. If the seller comes to close and their closing's at 10 and the buyer can't make it until 4, then that seller is not leaving with a check. We can't give them a check until the buyer has closed. And often it's not even funded. The mortgage company doesn't always fund it until it depends on the company. That's one other thing that we've learned, is how different mortgage companies can be. It is not one size fits all at all. Some of them are happy to give us the money the day before, and we just kind of get them documents later that day. Others won't fund it until we get the paperwork, so that can cause a delay. So if you have somebody with a strong need to be leaving with the check, you need to be communicating with us about that, so that we can we can let you. It's not always possible to get them a check that same day. We do our best. So there are yeah, I'm just sorry. I'm just reading Kristen's comments about fighting liens. It's hard, especially IRS liens. Those are really, really hard to get just discharged. Those are probably the toughest because you can't get out of them in bankruptcy. They don't just go away over time. Yeah, that is a tough. I don't know that there's a good answer. So if you are ever in danger of getting an IRS lien, do whatever you need to do to not have one of those. Pay your taxes. So my favorite mortgage companies, and maybe for us, like favorite is like easiest to work with. I don't know. I'll let Crystal name names. I won't say non-favorite. Who's your favorite, Crystal? Give us top two.
I would say Mercantile is very easy to work with. They're very responsive. They tend to get things over quickly. So they've done a really great job. We've enjoyed working with them a lot. And I will say, I'm sure you guys probably tell your clients very similar things, but the really large national companies tend to be a bit more challenging to work with from the title side as well, just because they often have so many layers of quality control and so many more restrictions that things just tend to take a lot longer. So, like I said, probably very similar to what you tell your clients too.
So there are, just speaking of splits, there are 2 policies that get issued at close typically. There is one that is issued that it's called the owner's policy, and it is something that is typically, unless there's a really unusual situation, but typically that is paid for by the seller, and it is going to cover the buyer and their interest on the date of close. They're saying, hey, we are giving you a warranty deed. This is clear title. The other policy is typically paid for by the buyer, unless they're having the seller pay their closing costs. But, and that is one that the mortgage company is insisting on to cover their interest, because they are putting a lien on the property to cover, if they're giving out a bunch of money, they want to make sure that they're not third in line and that there's an insurance policy there in case something happens where they are third in line. So the thing to realize with that, and that lender policy is only for the loan amount. So when you get your title commitments, that would be something to notice, and usually the mortgage companies know this, but to let us know right away if that is going to be a different dollar amount than what we first thought, so that we can adjust our policy to reflect that. The other thing, and kind of getting back to my comment about how title companies are first and foremost insurance companies, and that's kind of the bulk of their revenue. Like that closing fee, it's nice, but it is not the bulk of the revenue. So if you have something that's a cash transaction where there is no, there's no second policy, you can't really split that one. So that's something that I run into, where especially newer agents don't necessarily know that. So I didn't want you to leave this class without knowing that if it is cash transaction, the seller is the one who is buying the only policy that's issued, and so they get to dictate which company you use. Obviously, that is negotiable like everything else. So if for some reason you don't like their company or whatever, have a conversation. But at the end of the day, they're buying the policy, and they are able to dictate where that occurs. I've had a couple people be surprised where they say, hey, I ordered title. And I said, why would you do that? We are paying for the policy. You don't need to order title from anybody. So just FYI. Okay, so ownership. There's a few different ways to take ownership. And oftentimes we don't run into it, and it doesn't really, I don't want to say matter, but it's just like a common enough issue that it just doesn't come up. if you have like a single person buying a house, doesn't matter. If you have a married couple buying a house, they usually take title as tenancy by the entireties. Those are our two most common. Now, the thing why I'm bringing it up from a realtor perspective when it comes up is when you have people buying a house together who are not married. So whether that is a couple who don't happen to be married, or if it's somebody with a co-signer who's going to be on title, they often have a decision to make, which is how do you want to do that? And I find it a little bit confusing, so I wanted to cover it with us today. There's tenancy in common, where it's more like owning stock. So if you have a house, let's say that you and a family member buy a lake house together, and you both own 50%. If you are tenancies in common, it's like you have a 50% interest, and if you pass away, then your interest goes to your heirs. So in the case of the lake house, that's the way you wanted it. You wanted your kids to enjoy it once you're gone, and that would be great for them because it's their cousins that own the other 50%. So good times. That would be tenancy in common if you want your share to go to your heirs. Now, if you don't want that, like in the case of a couple that's not married, they probably want their interest to go to their significant other, the person that they're buying the house with. That is different. If you want your ownership interest to go to the other owners, so if you used to have a 1/3 interest, someone passes away, then it would go, then all of a sudden the remaining two would be 50-50 owners instead of 1/3. Their ownership interest basically just dissolves. That would be joint tenancy with the full rights of survivorship. Now there is kind of like a hybrid, which is a very unusual situation. I'll just kind of touch on it so that you're familiar with the term. That would be joint, just plain old joint tenancy. If you own something a third, just as example, and one of the partners, partner A, falls on hard times and wants to sell his interest. By default, that his ownership interest then becomes tenancy in common. So it can become this like hybrid thing where that new owner, their share will go to their heirs. The other two remain a joint tenancy where their ownership interest basically dissolves with their death. It goes to the people who are still owners. So that's just something that's good to understand. If you are sharing a lake house with some partners, you want to make sure that you take title correctly. It's just a conversation to have. Again, we don't run into this a lot as realtors, except for in the case of unmarried buyers and co-signers. So, and that'll be something, for those of you who have been on my webinars before, you know that we have a Facebook group called Clarity Conversations. Go ahead and join that, and we will have a resource there for you that kind of explains the different ways that you can take title, so that if you do have a situation where someone is a co-signer and they want to understand the different ways that they can take title, it's kind of it's kind of confusing. You can just hand them this piece of paper instead of trying to remember the difference between tenancy in common, joint tenancy, tenancy with full rights of survivorship, and tenancy by entireties. If you have any questions, let me know. I may or may not know, but that is what I do know. Okay, then there are a few different ways to convey title. Warranty deed is what we see most frequently. That is what the lender wants. What a warranty deed is the grantor. So the grantor is the person that is conveying title. he's making some statements by signing a warranty deed. He's saying that he is in lawful possession of the property. He has clear title to convey the property, and he is making a guarantee to the grantee that he'll be able to enjoy the property without interference from others. This is why you need title insurance, because you can't make that kind of claim if you don't know those things. The other way, there's a couple more ways that you can convey title. The other one that's really common that we see all the time is a quitclaim deed. We see it all the time, like if, I don't know, you used to have a co-signer and now you don't. So you want to get their interest off the property. Or we'll see people do it shortly after close, where they buy something as an individual and then they want to put the property into an LLC. So they'll do a quitclaim deed for that. It's really simple, it's really easy, it's really fast. That's why people do them. Does not have the same teeth at all as a warranty deed. What a quitclaim deed is saying is whatever interest I may or may not have, I give to you. You don't even have to have any interest in a property to do a quitclaim deed. I could do a quitclaim deed on your house and give all of my interest to my son. I have zero interest, but that doesn't stop me from doing a quitclaim deed. Doesn't have any bearing, doesn't matter. I don't know why you'd do that, but you could. You can do a quitclaim deed and it just says, hey, I'm not making any guarantees that I even have anything to give you, but if I have something, now it's yours. That's quitclaim deed. The third one that I just kind of wanted to touch on is a covenant deed. A covenant deed is pretty darn similar to a quitclaim deed in that they're not saying that they have ownership interest. A covenant deed includes only covenants pertaining to the acts of the grantor, but not those of any other person. We don't see these as much anymore, but that was kind of like the way that banks were conveying title. They did not want to be on the hook for anything that may or may not have happened before they foreclosed on the property. As a title company, what we do is we take a look at that, make sure that the foreclosure was done legally, kind of get the warm fuzzies that we can. And the banks basically refuse to sign a warranty deed. They just say, here's your covenant deed, take it or leave it. So if somebody actually wanted to purchase the property, they'd have to be okay with it being a covenant deed, which means that your title company has to be okay with it being a covenant deed. I know we are. This is another case where we call it insuring over it. And that it was a really typical way of dealing with it. They just take a lot more caution in making sure that that was all done correctly. Okay, I have a question here. How does a title company do the title? So I'm not 100% sure what you mean by that. So Maria, I might ask you to clarify a little bit. So the title is such a generic term in a way. It can mean like conveying title would be all the deeds that I was just talking about, the different kinds of deeds. And that's generally something that we do prepare in-house. We will, and even if somebody else usually it is the dispersing title company, the buyer's title company that will record both the mortgage and the deed. But the seller's title company prepares the deed, but then we give it to them to review because they want to know that it is something that will be recordable. Crystal, if I'm ever saying something that's not quite right, feel free to to speak up. But it's just basically for us a Word doc. I don't know if it's generic per se, but it has to be in a format that's recordable. So it's really the county that dictates a lot of that. Oh, okay, she's asking about the ways to take, yeah, thank you, Maria. What she's actually asking about is if you're joint tenants or tenants in common, tenants by the entirety. So it doesn't come up very often. If you're a single person or if you're married, then it's assumed. The only time it really comes up is with is with a co-signer, is the most typical time. And some of that is the comfort level of the mortgage company. Like us as a title company, we'll often just get instructions from the lender telling us how they want it to read. So that might be another reason that it doesn't come back to the consumer. But that's the only time that we really have gone back. Crystal, do you have any other comments about that? Why they don't hear about that more often? Do we just always do it? We don't always do it as tenants in common, do we?
No, it's not always tenants in common. I mean, so often it is a married couple, and that's just automatic. Same with if it's, a single person. But when there is a co-borrower, a lot of the time the lender will kind of already have had that discussion with the client. And if they haven't, then they might rely on us to do that as well. So it doesn't often go to the actual realtor. It's usually handled kind of behind the scenes, a lot of the time with the lender and the client.
So hopefully that helped. But thanks for the question. Okay, title. I want to talk about title commitments, and then kind of as part of that conversation, what are things that you should be looking at? Because I fear, and for good reason I fear this, I know for a fact that this happens. I'm going to look right in the camera so that you know I'm talking to you. I know, I know that you realtors, I'm myself included, not everybody obviously, and when you're busy, you do this more often. I get it. But when you get that title policy, don't just throw it in the file and check the box saying, I got a title policy. Now, 80% of the time, you're probably fine to do that, frankly. And there aren't big things. The common things that we'll see on a title policy is the mortgage that's already on it needs to be discharged. Make sure your taxes are paid. Like those are the common things that we run into. But when there are other things, they can take a minute to get cleared off. And so you want to know about that as quick as possible. So if you don't read your title policy and you're just relying that somebody's going to call you, oh, Kristen, I knew you would. If you don't read it or you don't read it timely, it might delay closing if you're not able to clear off whatever needs to be cleared off. Or if there's follow-up that maybe is easy, but you need the attorney to get involved and he's on vacation or whatever it is, you just want to know about whatever, you just want to know about whatever's on there. So I am going to share my screen and show you one of our title commitments. The format of them can vary a bit from company to company. So this is just what one of ours looks like. I'm gonna get rid of the thumbnails on the side so you can see it better. So on our commitments, we have a little summary page. And I wanted to use this one as an example because, and this is to help us solve the problem of people not necessarily reading their policies. If there are items that really need to be addressed, then we are going to go ahead and put this stop. And it kind of depends on how bad it is. We kind of have we have like green, like good, everything that's on here is coming, or yield, like it's probably something you have around the house, but there is some follow-up that we need. Or we have stop. These are things that probably are gonna take you a minute. Yeah.
The other title commitment's actually up. Can you put the one with stop up? Or rather, the one that's showing.
So you're not seeing the one that says stop?
No.
I don't know how to get rid of the other one. Let me see here. I guess I just have to close it. Shoot. Thank you for letting me know. I took Adobe Reader off my computer because it takes over the whole thing, but now I wish I had 2 different reading programs because that makes Zoom easier. But anyways, okay. Thanks for letting me know, Crystal. Especially when I'm sharing my screen, I don't see the chat. Okay, so in this, what made it high risk? Crystal, do you want to tell the story on this one a little bit?
So this is not super uncommon or anything. In this case, there was a prior owner's mortgage that was not actually discharged. So we lucked out in the sense that it had actually been paid off. The discharge was never actually recorded. Had the mortgage not been paid off, that would have been a significantly bigger issue. But of course, there's that big stop at the top saying, hey, we really need to take care of this because it's really high risk, of course, to have someone else's lien still outstanding. So for this one in particular, like I said, we lucked out. It was already paid. So we were able to reach out to Huntington, and then they were able to confirm that it was paid, and they said, okay, yeah, we're going to record it for you. So they sent us a letter of intent to record, and we were able to close. That said, it of course took some time to get that letter of intent to discharge. So I think we ended up closing about 2 to 3 weeks late because we were just, at their mercy whenever they got around to it. So that's a really good example of something that can delay closing a bit, and there's just nothing that you can do to speed it up. You kind of just have to wait and continue to follow up.
Yeah, I've seen this same type situation more commonly with if somebody had a home equity line of credit on the home, and then they sell it, that the discharge would be on the main mortgage, but the home equity line doesn't get discharged, especially if it didn't have a current balance on it. And I know I've run into before where it was like with Old Kent Bank, and that obviously isn't around anymore. It got bought out, and of course all their systems are different. So those are things that come up that definitely, the quicker you know about it, the better. So this isn't officially part of the title commitment. This is just a summary that we do to make it a little bit easier to read. And this is where you're going to see like how they're in title. Why it's important to know their marital status. This is the commitment. This is the title company saying, yeah, we'll give you a policy if you follow our rules. Every title policy has a Schedule A, Schedule B1, and Schedule B2. So Schedule A is kind of like the summary of here's what our title policy is going to be. So we're the agent of record there, Graybridge Title. This is the owner's policy, which would be for the sales price of the house. This particular one was $150,000. The proposed insured would be the buyer's name. So you do want to read that, make sure there's not misspellings, that kind of thing. Then the second loan policy is for the loan amount. And in that case, the proposed insured is going to be their lender. So if they do switch lenders, that's something that we need to know. And usually what'll happen is I kind of like to get the pre-approval letter, like when you send over the title order. It doesn't have to be this way, but when you send over the title order, usually people just kind of send us the purchase agreement. And that's all we really need to get us started. And if we know who the lender is going to be, like send over the pre-approval letter, then we can reach out to them. And then what they do is they'll send us an order so that we know more of the details of the of what needs to be on that commitment. Then Schedule B, Section 1 is the requirements. This is saying, if we're going to give you title insurance policy, here's what needs to happen. A lot of these are standard. 1 through 6, see how they're smaller? They're the standard ones. Boilerplate doesn't, I'm not going to say it doesn't matter, but that's not the ones that we need to detail read. What we do need to detail read are the requirements of this specific one. Normally what it is, is who needs the mortgages that need to be discharged, the names that need to be on it, what's the new mortgage, etc. And making sure that all the taxes are paid. Then exceptions. This exceptions is where you're going to find things like we were talking about before that don't keep it from being financed, but it might hinder your enjoyment of it, like encumbrances of some sort. If there's a road that goes over the middle that you can't get rid of, like your neighbor has access through your property, something like that, that's going to show up here. Doesn't necessarily hinder you from getting a loan or anything like that, but probably is the kind of thing you'd want to know about. So this is where the client would probably be interested to know. Now, it's not typical, but this again is the thing that like surveyors are going to look at. And a lot of this is just the general, like so exceptions just means here's the things that are on it. They don't need to change, but we are not going to insure it. If later you decide that you don't like that encroachment, don't ask us to sue that person for you, because we're not going to. We told you this was an exception to your policy. But it's basically, at least for this one, is all like the standard stuff. Nothing really on there as far as like access liens or anything. Now we do the legal description as Schedule C. A lot of them have it in as part of Schedule A. Again, this is the other reason that the surveyor likes to look at the title work. Then the rest of this is just kind of everything that's always in a title policy. So that's kind of just what the general overview of what goes on with the commitment. Now I'll see what chat I have in there. Okay, so if there are things that come up, I want to tell you about like the general ones and what gets recorded, just so you have a heads up. Even when you're going to list something, if you know that it's part of an estate or part of an LLC, what do you need? Okay, as far as specific questions that are more like a story, so to speak, it's a great example of things that come up. I'm gonna hit it at the end, especially because we're growing short on time. So here's some general requirements that we run into that you should be aware of. In the case of a trust, you need to have a certificate of trust existence and an affidavit regarding trustee powers. Now, the certificate of trust existence does typically need to be like newer. That can vary from title company to title company, what their comfort level is as far as how new it needs to be. For us, we don't necessarily care the exact date, but we might have them sign at close that this is the most recent trust that exists. Should title have caught the wrong legal description? Sometimes. Yeah, it kind of depends on, sorry, I'll read the story better about because it depends on why the legal description was wrong. Some of those things we can catch, and sometimes we don't. It kind of depends on the origin. So certificate of trust existence. So sometimes that's a good thing to be aware that they're going to need that, so that if they need to go to their attorney and get one, that you're aware of that. So when you go to list, you find out that it's in a trust, ask them if they have that, and if not, have them get it from their attorney. If it is in an LLC, we are going to need the operating agreement and a certificate of good standing. If it is in an estate, we are going to need the letters of authority to establish who is qualified to act as personal representative to the estate. That is not the same thing as a will. A will does not help us. It's something that you get from the courts. If you have a will, it's relatively simple to get from the courts. And most of the time, people have gone through it already. So they have that. Like when you go to list it, you say, "Are you the personal representative?" And they say, "Yeah, here's my paper." I've had once or twice where they didn't really know what I was talking about and they didn't think they needed it, but you do. But it's not hard to get. And then as far as what gets recorded with an estate, the death certificate and the letters of authority both get recorded, unless the full probate information is indicated on the warranty deed, then you don't have to. So it kind of just depends on how private they are and what they want, but there are going to be some things that do need to get. Sue, do you have a question? I didn't mean to ignore you, but I see that hand. If you do, go ahead and speak up, but I'll keep going. So the divorce, if you're in a divorce situation, those tend to be the craziest. Some of them are amicable and some of them are not. And as I mentioned before, sometimes the way they split the equity was not as equitable as they thought that it was. That doesn't matter. You can't really renegotiate that. If the lien is for $100,000, we as a title company can't make the call to say, "Oh, I know they met 50%. Like that's not up to us, of course. We've actually had a spiteful ex-spouse just say, "I know there's not enough equity to pay me off. I don't care." And she just let it go to foreclosure. Super mean, but it happens. So if there is a divorce, we do need to see the judgment of divorce. We only need to record it if the ex-spouse refuses to sign a quitclaim deed. Then and most of the time people don't want it recorded. Who wants all the details of their divorce on public record? But if you know that they were on title and now they're not, if their interest wasn't discharged with the quitclaim deed at the time of the divorce, that is something that we're going to need to have happen. So make sure that you get that. And I mean, I've seen where they're like, "Hey, you want to sell the house and you want me to sign something? Then I'm going to need this, this, and this." Obviously, that's not our fight, but it's good to know that there's a fight coming so that you can give your client the heads up if there's something like that. If there is a death, but it's not both of them, like if they're one of the spouses has passed on, there's nothing obviously to be signed, but we do need a death certificate. So typically when someone passes, they are given, 5 or 6 copies of that original death certificate, or you can get them from the Register of Deeds, but it does need to be an original death certificate, not a copy typically. Although funny, Ottawa County gives you a copy and then they give you a letter that says it's not notarized, but it's the same thing. So I just find that funny. But Kent gives you an actual notarized death certificate. And that does need to be recorded. Okay, so that is our hour.